Good afternoon. It is Monday, July 28th. Welcome to the Transportation and Environment Committee. There are two items on our agenda this afternoon. The first is Bill 1825, Forest Conservation Trees. This legislation proposed by the Planning Department is intended primarily to align the county code with recent changes that the state enabled us to make. In addition to technical and clarifying revisions, the changes address trees saving plans, afforestation as it relates to solar photovoltaic facilities. Retention requirements and reinstatement of forest mitigation banks that protect existing forests. I know that there was a lot of testimony about the definition and particularly the size of trees. I know we will get to that with an amendment that has been proposed, but I will turn it over to staff to fill in the gaps.
Absolutely. Thank you, Chair. I apologize in advance. I just noticed my jacket is on the 6th floor. Senate Bill 526 of the 2023 regular session amended the Natural Resources article of the Maryland Code, updating portions related to forest preservation and retention, as the Chair mentioned. Along with the changes mandated by these state law revisions, the Planning Board's proposed bill and regulation included other minor changes intended to clarify and update county law. We have received the fiscal impact, racial equity, and social justice impact statement, as well as the climate assessment, all of which indicated there would be either no or a small or minimal impact. As the Chair indicated, there was a fair amount of public testimony related to this, both in support and in opposition. Those testifying or submitting testimony in opposition to the bill primarily testified that it went beyond what was required under state law and specifically opposed the bill's definition of a tree, as the Chair indicated. Proponents primarily suggested the bill would enhance forest conservation, but did voice some concern about changes made to significant and champion trees. There is one amendment that is in the packet that was being offered by Councilmember Balcom. I'll note for the committee, there was also a second technical amendment that I'm going to propose afterward from staff that is not in the packet. I don't know if Councilmember Balcom, if you would like to speak to that first amendment or...
Well, thank you. Thank you for that background. Also want to welcome Councilmember Luedtke, who, as the packet notes, has proposed an amendment with Councilmember Balcom. So we'll turn it over to Councilmember Balcom.
Sure. So thank you. Thank you for the packet and the conversation. So as you mentioned, as was mentioned, a lot of the testimony that we received was the concern with the 1-inch caliper. We heard from Montgomery County Farm Bureau, Ag Advisory Board, Ag Preservation Board, Montgomery Agricultural Producers, and the testimony from the Montgomery Soil Conservation District, they're here today, thank you, really does go into really great detail about why this is so, why that definition is has such an impact on farming, which I don't think was intended, and the difference between trees and saplings, and why the new definition would hinder normal maintenance of their fields. So the amendment is in the packet, co-sponsored by me and Councilmember Luedtke. Thank you. And basically what it does is it just reverts back to what was already in the code and eliminates measuring at least 1 caliper out of the definition. So I'd like to make that motion. I'll second.
Second. Welcome, Councilmember Luedtke. Do you want to comment on this? Yes.
Yeah, I just would like to hear from the planning staff, since and thank you to everyone who provided public comments. We know there's a great deal in the update. Much of it is technical, and this was one area that was raised, and this is why we have the process we do. We have people being able to come to us during public comments, but then have a committee session so that we can kind of dig into the details. And before moving forward, I'd just like to hear from planning staff about what they're hearing and their thoughts on this.
Thank you. I'm Christina Sorrento. I'm the Chief of the Environment and Climate Division with Montgomery Planning. So I have been working with forest conservation law for about 17 plus years, and this is the definition we've always used. So technically it wouldn't make any difference in how it's interpreted, but we are okay with the change just reverting back to the way that the law is currently drafted. The only reason why we made this change was to make it clearer to anybody about how the staff applies what the definition of tree is, because as it is currently written in our law and in the state law, it can go down to any size at all, even much smaller than 1-inch caliper. And so we wanted to start somewhere, and we had talked to DNR many years ago, and they agreed that we could start with a 1-inch caliper instead of going to a 1/2-inch caliper or smaller. So, but this, we're completely fine with the amendment.
Great, thank you.
So I just want to pick up on that. I appreciate that question. So if this is a working definition within the department, is it a distinction without a difference if it's removed from this?
Yes, that's correct.
Okay, so we want to clear up any confusion here, but for practical purposes, the planning department still has its definition.
Yes.
Okay. Councilmember Ludke, welcome. I don't know if you want to comment on your amendment?
Nope, I think it's
Great.
pretty straightforward.
Okay. So all those in favor of that amendment, raise your hand. That's unanimous. Any other questions or thoughts? Okay. Again, we've made the technical legislation, brought it back to its roots of being technical. And so I think with that, let's have a formal vote.
Sorry, Councilman.
Oh, you had a second
Yes,
amendment.
The second one. Speaking
Thank
of
you.
technical, I'll be very quick.
Thank you, Mr.
So
Rafael.
one of the revisions that is on line 13 through 15, and then scattered amount within, defines mixed income community plan. So that had been added because mixed income community plan was part of the FAITH Act from 2023. The last time that the forest conservation law was updated was about a month before that ZTA was passed. So that was added, but in ZTA 2503, which was passed about a month before this was sent over by the planning board, all of those biohealth priority campus plan reviews, the mixed income community plans, commercial resident, that was all collapsed into 7.3.5 expedited approval plan. And so council staff would like to propose that we delete that definition, this newly added definition in lines 13 through 15, replace it with a definition that reads expedited approval plan means a plan that is approved under section 7.3.5 of chapter 59. We would also delete the definition of biohealth priority campus plan that is presently in chapter 22A. It would not appear in this bill because it was already existing. And then anywhere throughout this bill where there's an enumerated list that will read it reads other site plan, sketch plan, things like that, but then it also will, wherever it says biohealth priority campus plan and mixed income community plan, we would delete that and replace with expedited approval plan. And as just to align with ZTA 2503, which was just passed before this bill was introduced by the council president at the request of the planning board. It also will have an efficiency down the road, so that if the district council at any point adds another expedited approval plan, we won't need to update 22A to accommodate that change. It will already be incorporated within the expedited approval plan language.
It reverts to that section.
Correct,
Right,
exactly.
okay, more broadly. Make sense?
Makes sense. Mm-hmm.
Great. So without objection, we'll accept that staff recommendation. Thank you. And now
And
we're
then
good.
that's all. Now final vote. Yeah.
Thank you. So all those in favor of this legislation, that is unanimous. Thank you. Thank you to the planning department. We appreciate you. Okay, the second item on our agenda this afternoon is expedited bill 1925, noise control leaf removal equipment seasonal exemption. This is essentially an amendment to a law that was just enacted on July 1st regarding the prohibition of gas-powered leaf blowers, the history of which was that the county executive introduced legislation back in 2022. It remained at the council until 2023 when this new council was seated. Only then did it have a committee session at T&E and multiple work sessions at full council. I think it had more work sessions at council than many other pieces of legislation that we discuss here in this body. And Bill 1925 would allow for an exemption of gas-powered leaf blowers during the autumn months. I will say that I strongly supported the original legislation and pushed as chair of the Transportation and Environment Committee and then as president of the council to move that forward. And it was a very robust legislative process. Lots of amendments were offered. Some were accepted, especially during the timelines. But I think we landed at a fair place. And now that the law is enacted and is actually in effect, I can speak firsthand and say in my community, I've noticed the difference. And I know that a lot of other residents and neighbors know the difference, have experienced the change, and have expressed their appreciation for our efforts not only to keep the lawn care workers safe from not breathing in the harmful fumes, but also keeping our communities quieter by switching to electric leaf blowers as well. I want to welcome Councilmember Albernaz, who sponsored this legislation, and Councilmember Ludke has remained for this conversation. Open it up to colleagues for any opening comments. Okay, Councilmember Albernaz.
All right, well, good afternoon. First, big thank you to Chairman Glass for scheduling this session because we do have sort of a time crunch. If this bill is to advance, it would be, it would go into effect this October. And I don't disagree with any of his comments. This did have robust conversation. There were a number of committee sessions. I participated in most of those. I've learned a lot more about gas-powered and electric-powered leaf blowers than I ever thought I would know. But I think what has changed since then is the reality on the ground. And I do want to give a lot of credit to DEP, who has, with fidelity, done their work to ensure that we stand up this law and let as many people know about it, particularly those that were going to be the most impacted by it. And I think they've done everything within reason to do that. I also believe that with great intentions, we provided a rebate program to help with the transition. That rebate program, by all accounts, has been a huge success. But we also have to acknowledge that for our landscaping contractors, that rebate program is really not much more than a nice gesture because it does not cover nearly as many pieces of equipment that the landscaping companies are going to have to incur. And as we've also learned, there are other expenses beyond just the leaf blowers themselves, which cost 3 times as much as a gas-powered leaf blower, but they've also had to spend, in some cases, hundreds of thousands of dollars in electrical infrastructure in order to be able to comply. And what I have heard overwhelmingly from landscaping companies is that they simply are not ready. And I'm concerned for them, I'm concerned for the Department of DEP, and I'm concerned for our constituents because I think when October rolls around and when these pieces of machinery are actually the most in use, you will still hear the gas-powered leaf blowers because landscaping companies are just not ready for this transition. And in DEP's own report, which I really appreciate and you all did a fantastic job of, it acknowledges the challenges of the transition and timing of the county ban, and it specifically states that the county's law implemented a year-round restriction change for the industry with only one fall season in between the implementation of the law and when it's going into effect. This is a massive change operationally to these companies, And we've only given them 1 season to both transition financially, but also 1 season in order for them to be able to test out this equipment when they utilize it the most. I have heard from the town of Kensington, the town of Chevy Chase View, and other municipalities that are putting a hold on the implementation of the ban of gas-powered leaf blowers. There has not been much pushback within those communities, in large part because people are worried about what's coming and their ability to actually be able to carry it out. So what the law asks for is not that we not stop the ban, just that we slow it down for up to 3 seasons. And I'm open to talking about that because any reprieve within reason that we can provide to our landscaping contractors, I think would be very helpful. And the last thing I'll note, Mr. Chairman, before yielding back to you is with your indulgence, there was some very helpful testimony provided by the executive branch that talked about a change in the policy with regards to the encouragement of taking of photos of violators. And I'd love to hear more from DEP and the executive branch on exactly how they plan on making that change and amending that, because that has always been a concern of all of us, but now even more so in the current political environment that we are in. And the fact that over 80% of the employees of these landscaping contractors are immigrants. So that's something that has to be taken into account. So with that, I yield back to you, Mr. Chair.
Thank you very much, Councilmember Albornoz. I very much appreciate your advocacy in this regard, diving deep into it and bringing your perspective and the perspective of other members of the community to the council. Without any other additional comment, I'll turn it over to Ms. McCartney-Green.
Thank you, Chair Glass, and I appreciate the introduction of Councilmember Albornoz giving a good history and background. I do want to just take a step back and refocus that the Bill 1823, the purpose of that was DEP had trouble enforcing noise, and that this is a noise legislation. There are co-benefits of it, of reducing gas emissions possibly, and looking at health adverse effects, but the purpose of the original legislation was to try to better increase enforcement concerning noise. I wanted to make sure that was clear for the committee. As mentioned, there were numerous testimony that the council heard and that council staff received. Had the opportunity to kind of put them in 3 buckets, and I'm on page 4 of the staff report, but those that testified in support of the bill obviously referred to the adverse economic impact that it would have. Looking at the financial burden of transitioning from gas-powered leaf blowers to the current battery equipment. And also looking at the steep costs of ranging from $900 to $1,600 for each piece of electric leaf blower. Also looked at the employee safety and efficiency, especially during the fall season. And so proponents emphasized that the electric leaf blowers were less efficient, and they also physically demanding for workers to carry and to use. Lastly was the technological limitations, obviously, of the current market being able to produce something that was as comparable. In opposition, referred to the environmental health impacts, also referred to the commitment to the county to maintain its commitment to transitioning, and the reduction of noise, not only for the community, but for potential hearing loss from employees that would use this, and also for wildlife in the area. Their opposition also included that from the executive branch testified in opposition of the bill, but also mentioned likelihood of agreeing to amending the enforcement section of the law, which was also mentioned. We have representatives here from DEP. The way how the packet is structured is talking about the rebate program, and then looking into some of the economic costs, and then there's an amendment by Councilmember Albornoz. So I'm happy to proceed with that, or I don't know if the chair wants to turn it over to DEP.
So I want to leave it to my colleagues to direct the conversation. I appreciate the direction which Councilmember Albornoz has pointed us in. I expect we'll get into that full depth of that discussion as well, but turn it over to my colleagues for any opening comments or questions you might have. Yeah, Councilmember Stewart.
Okay, I can go first. One, I just want to say thank you to my colleagues. We, as the chair said, this was a conversation. I think it was one of our first ones we had as a council, and I think it was a good one because we also learned a lot about procedures, like when we table something and who can bring it back. And so this legislation, the original bill, went through quite a bit. I do also want to note that as an issue, this is one that actually for me goes back a number of years, because when I was the mayor in the city of Tacoma Park, this was something that folks pushed for there and talked a lot about. And as the chair mentioned, this was a topic that the prior council had been taken up and talked about, but unfortunately legislation never advanced with that. So I will say I have residents and looked at this issue for not the last 2.5 or 3 years, but at least 5 years of really thinking about how do we advance this work in the county. And some of our municipalities have moved forward with it. We have the District of Columbia and other jurisdictions. So while I appreciate the testimony we heard and hearing from my colleagues, for me, I think we should stay the course on this and continue as we have been. I do think we need to go back and look at the enforcement. It was, as Councilmember Alberno said, I think a lot of us, when we were doing this, were really wanted to emphasize like the education, the moving forward, the transitional period, and really just being very conscious of where we are right now in our country and thinking about how we're doing that. But you know, for me, I'm comfortable staying the course with where we are. Want to thank DEP for the work they're doing and looking at, are there other ways that we can connect our businesses with other, you know, if we need to look at our rebate program here to do that. There are other regional rebate programs that are go on in the region. And there are other companies that are looking to help people and businesses make this transition. And so to the extent we can facilitate that, I would be for that as well. But I think we should stay the course, and I won't be voting in favor of this bill.
Thank you. Councilmember Palpin.
Thank you. So when this committee initially discussed the initial leaf blower bill, I had a lot of questions about how the ban would move forward logistically. I'd forgotten that I had actually tabled the bill, primarily because of the rebate program. And there were a lot of questions about how that rebate program would work and the concern of a first come, first serve and how that would work. And I was then and continued to be concerned about how this would impact our business owners, particularly our small business owners. DEP has done an outstanding job of with interacting with the public, getting the education out, and the rebate program has been in place for two cycles now. Although we knew going into the rebate program that there would be considerable budget constraints, as Councilmember Albanos mentioned, there is just no way to adequately compensate our commercial landscapers for their investment, their significant financial investment in this technology. We still have an outstanding issue on how this law is going to be enforced, and I do want to have that conversation today before we go. We heard during the public hearings, many of the commercial landscapers have converted much of their equipment already to electric blowers, but they're not, as we've heard, not ready to handle the significant increase to take care of the leaves. And it's not that the landscapers waited until the last minute and they aren't ready. It's that the technology isn't ready. The technology to move that amount of leaves and given the short period of time frame to do that. You know, and as legislators, it's a very important goal, a very worthy goal. And I really struggled. I did vote for the initial bill, but I really struggled. And I believe at this point in time that it is we did too much too soon. And a few weeks ago, I did take a trip to Home Depot, and they showed me the majority of not just leaf blowers, because by law they can't sell anything but electric leaf blowers, but all the other equipment, the handhelds, lawnmowers, et cetera. And so industry is moving in that direction. And I had an opportunity to meet with two of the manufacturers, the two top manufacturers in the electrical equipment. I tried on. I couldn't wear the pack. The pack is too heavy for me to wear. But I tried to do the leaf blower and also the lawnmower, and it was really educational for me, and I'm glad I did it. But I asked about the issue of, are these products, these are the sales reps, are these products, can they handle the leaves in the fall, particularly the wet leaves? One of the manufacturers right off the bat said, nope, no way, we're not there yet. The other manufacturer was very confident in saying, absolutely, this can handle the wet leaves. And I said, great, how long does the battery last? 30 minutes, right? On high. If you wanted to blow leaves on low, you could blow leaves for a lot longer, but it would take days. But so the issue is, when we look at the technology and we look at the logistics of it, if you've got a crew out for 8 hours a day, they're blowing leaves for 6 hours, that's 12 batteries. So the cost of that and the logistics of it. I think that the use of leaf blowers in the spring and the summer is so much different. That the wear and tear and the burden of the leaf blower is much different in spring and summer than in the fall. So I co-sponsored this bill. I support the bill. And then the other issue that I just wanted to say is that it is important for me to listen to business owners and listen to the industry. And I want to be loud and clear that there's no caving in. We talk about how Montgomery County needs to be partners with our business community. That means we need to listen to our business community. And they have told us that this is not going to be not even be effective, but it's going to be extremely difficult for them to continue to do what they're doing. So I continue to support this bill, and I do want to have the conversation about enforcement. Thank you.
Thank you. We will get to that, and I do want to ask about the appropriations that DEP has already used that were in the budget for this conversion, but want to invite Councilmember Luedtke to make any comments if she has them.
Thank you. Yeah, I too supported the original bill, like Councilmember Balcom, but I also recognized at the time, and I did propose some amendments to the bill at the time to try and make it what I thought would be more workable or more reasonable, particularly as Councilmember Balcom and I share a part of the county that has different landscape than other parts of the county where the lawn work and the landscaping processes require different things. And as I recall from the prior bill and the work we did on that, the difference in decibels between the two devices is 9 decibels or thereabouts. Is that right, Ms. McCartney Green?
Yeah, that sounds about right.
Okay. And I want to say that I live on a 2-acre property in the woods, so I have a lot of leaves, and I have an electric leaf blower and an electric weed whacker, and I have 2 batteries for them, and I cannot finish with 2 batteries total when we have to do work. So we do pieces at a time, and we constantly have to cycle through the pieces, right? Because we're trying to the point of other legislation pending, deal with invasives like Japanese stiltgrass, which you have to cut down before it goes to seed. And I'm speaking that now because we're getting into that time when Japanese stiltgrass is going to go to seed. And as everyone who deals with it around Montgomery County knows, it's awful. It's a pain in the neck to eradicate. And we want to eradicate naturally, right? Because we have other rules about not using chemicals to do so. So my concern with this is in listening to the commercial operators, much like Councilmember Balcom, is that, you know, we were trying to find a medium meeting spot where we weren't totally abandoning this, where we were giving a bigger runway toward getting to the technology, and we were acknowledging the shortfalls of that technology. Because, you know, some things are good for residential use, like they have now. They're not good for larger scale projects or all day long. And I'll be candid, you know what they said the solution is? Plugging them in to generators that use gas. That's kind of defeating the purpose, even though, to be fair, what we have the authority to legislate in is a noise-related situation. We actually don't have the authority to legislate in the electric versus gas environmental way that many people have spoken about this bill. So I want to be clear about that. Our authority is limited, very limited, and very narrow. And I am interested in the enforcement discussion, which must in fact center around noise, right? But given those things and given those impacts and trying to find the best way to get us toward greener, healthier technology while also recognizing the limitations of the things that are available to the commercial market right now, this seemed like a positive way to compromise in the interim as we get ourselves to where we need to go to make sure we are having both in the personal use and commercial use greener technologies. So with that, I'll turn it back to the chair.
Thank you. Councilmember Albanese, do you have anything else you want to add before we get into? Great. So what I'd first like to do is talk about just the rebates, because we've been talking about the money that the county executive and this body has allocated. That was a central part of the passage of the underlying bill to make sure that we could support that transition. Can DEP speak to how much funding has already been given to residents and also private landscaping companies towards this transition?
Hello, good afternoon. Amy Stevens with Watershed Restoration Division of DEP. May I ask a quick, are you asking about what happened in fiscal year 25 or fiscal year 26? Since we're in fiscal year 26.
I would say as long as for the funding that has been provided, how has it been allocated? Yeah.
Okay. So in fiscal year 25, we allocated we gave out $325,000 in rebates. We had $300,000 appropriated to us, and we shifted some money over from outreach and education to provide more rebates to the residents. In fiscal year 26, we again had $300,000 appropriated to us, and we're currently in the process of going through all of the applications that have come in and have begun to issue vouchers. But we're kind of early in the stages of that, and we need to see how many vouchers get redeemed before we can figure out how much is actually going to get allocated. But we are appropriated for $300,000.
And can you break down that allocation? Because I know that there was an emphasis on property owners, on residents, and then also I think a larger set aside for the landscaping companies.
Yes. Oh. Hang on a second. I know we have it. I'm just.
We actually, I think we just wrote out the numbers of how many we gave out, but of the 325,000, 30,800 was residential, and the rest was.
Okay. Do you want to say? Sorry, Mary's missing, but we're going to actually speak on the mic.
Confer amongst yourselves. That's okay.
Mary Travellini, also with Department of Environmental Protection. Last year with the rebates, we, as Amy mentioned, we gave out $325,000. 30,800 of that was to residential rebates. They received $100 each, so there were 308 of those. The rest were all commercial of 205, and they varied between $1,000 and $1,500. I believe 11 of them were the $1,000. They were the revenue non-qualifying businesses, essentially the businesses that have a larger income that got the 1,000.
What were those, that range? Did you 1,000 to 15,000?
1,500.
You said 1,500. Okay. And so it sounds, based on those numbers, is it 2/3 or 90% went to landscaping companies?
It was about 10%, a little over 10% went to commercial, so about 90%, almost 90%
Oh, so it was the
went to
inverse.
commercial.
Okay. Okay. Thank you for that. Yeah, jump in on while we're talking about this.
Yeah, so I think it's important, and thank you for that. The bulk of that went to the very small landscapers, which was part of the focus was, so these are landscapers with 5 or fewer employees. In terms of the non-qualifying landscapers, ones with over 5 employees, I have had conversations with them about why there's so few of them that took advantage of this. Part of that is the the cost benefit of going through the process versus going to one of our large distributors, and many of our large distributors gave their own rebates or their own discounts, and so they didn't go through the county to do that. So it wasn't that that the large landscapers didn't purchase electric equipment. They just did it through large distributors, and they got a better deal than coming through the county to get the $1,000. So I just wanted to mention that.
Yeah, Councilmember Albanese.
Thank you. And so just to be clear, what we were offering to the commercial realtors, the commercial landscaping companies was between $1,000 and $1,500. And according to the packet, that meant that there were 205. 766 rebate vouchers were issued, 513 were deemed, 308 were distributed to residential, and 205 were distributed to commercial businesses. And the rebate more or less covered the cost of about 2/3 of one blower, I think is what it comes out to when you factor in how much it costs. Just to put that into scale and magnitude, one of the landscaping companies who represents about the average size of a larger landscaping company here in Montgomery County had purchased 28 to date and needed to purchase 60 additional blowers to be able to accommodate the workload that they had during the previous year. And so while a nice gesture and appreciative, it paled in comparison to what the overall costs were going to be to actually be able to implement the new law and follow the law. And as Councilmember Balcom noted, just as is the case when commercial landscaping companies buy their equipment, they buy them in bulk from these companies for all of their equipment, because that is it's economies of scale. And so, but they are still in the thousands of dollars range, and while there is a discounted price when they're buying by bulk, it only represents typically between a 10 and 15% decrease in overall cost. And so they're still spending hundreds of thousands of dollars more than they otherwise would have had we not enacted the law. So the good news is lots of people are taking advantage of the rebate program, and in fact, my understanding is that it's been closed off because it's been so successful for the commercial owners, but again, it represents a very small percentage of the overall cost and is appreciated, but doesn't even come close to putting a dent in their overall expenses.
Okay, thank you. I was waiting for any comment, but appreciate the statements. Yeah, Councilmember Stewart.
Sorry, just to add on what Councilmember Balcom said about different rebate programs and other things is I don't think when any of us were discussing this bill the first time around, overall, we thought our incentive program, rebate program, whatever we want to call it, was going to be the be and end all for our businesses. We had a robust discussion about that. And I do just also want to add that, regionally, there are things like the Clean Air Partners that do rebate programs, trade-in programs, and that's a partnership of the DC Department of Energy, Maryland Department of Environment, PEPCO, Washington Gas, and Virginia Department of Environment. So there are a lot of efforts going on to move the industry in this direction, and a great deal of momentum. And I just wanted to build on that I don't think, even when we were having conversations about the inception of our program, did anyone on this dais think this was going to cover all the cost of the transition? So,
Thank you for that. I'll turn it over to Councilmember Malcolm.
So thank you, and I agree with that statement. So I guess, can we talk about enforcement and how will enforcement be? How currently, because the law went into effect in July, and we initially thought that neighbors, this is all complaint based. We know that, as most of our legislation is, and so to avoid neighbors out there taking pictures of other neighbors, which is in this climate we can't have. What are your thoughts now about enforcement?
Good afternoon. I'm Stan Edwards with the Division of Energy, Climate, and Compliance. Just a little information on what's happened to date. So since the law took effect on July 1, we've opened 76 cases, so about 3 a day. The law currently does require a picture to be submitted with the complaint. We've gotten pictures that have been very helpful. We had one complaint. We contacted the company and they said, no, we were using electric leaf blowers. And then when we showed them the picture, that was evidence that they were in fact not doing that. We understand the sensitivity about that. We do think the picture is helpful, but understand the sensitivity. So there can be a very simple change to the law to remove the picture requirement. Generally right now, all noise cases right now are based on either a DEP person with a noise meter, or another individual. Police can use a noise meter, although they're not equipped to use them right now, or what's called a two-party noise complaint. So 2 parties can attest that a violation is occurring, and we'll take that and can take an enforcement action on that and go to court with that. And the 2 parties have to be at court to be the witnesses, since a DEP staff person didn't see it. So we could either have a 2-party noise complaint or a single-party noise complaint and just remove the photographic requirement. And we've worked with the county attorney, and I can share that language with Ms. McCartney-Green on how to do that. So we do think if we were to go to court, it would be the complainant against the alleged violator, and without any photographic evidence may be tough, but we don't know. We haven't gone to court yet on these cases.
So I would assume that most cases they'll pay the fine and not go to court?
No, I don't think we have enough history yet, since the law's been in effect less than a month. But
you never know.
Don't know. Yeah.
And then the noise meter. So I would assume that DEP is not set up to answer complaints, to go out to a home or a residence and check the noise meter in real time, correct?
Right.
Yeah.
Right. We don't have enough staff to, when we get a call, and we've gotten those calls, say someone's using a piece of equipment, and can you come out? And by the time it gets to one of our investigators, we have 5, 6 that cover the whole county on all environmental. So we can't get there, and generally landscape companies or homeowners work pretty quickly in their yard, so they're gone. So that's always been a challenge in enforcing the noise law, which is why the 2-party complaint process was put in place. I think there was a recognition that the department wasn't staffed to do most noise complaints.
Okay, thank you. And I'm assuming, Ms. McCartney-Green, we'll look at that language in terms of removal of the photo.
Yeah, and I want to make sure, just as introduced, the bill was to put a seasonal ban, but the way how the bill is advertised, it also covers generally any amendments to the noise control. So yes, we would be able to amend that if that was the request from the committee.
If I could, I think one important thing is, do you want it to be a single-party complainant or a two-party complainant? Recognizing that the challenge of a two-party complaint is, if I'm walking down the road and I see someone using a gas leaf blower, and it's a two-party complaint, I've got to find somebody else to sign the complaint. So, but you want to
Just for clarity, they're under two different provisions. So the photographic evidence is under Chapter 31B, I want to say 9. But the two-part complaint is also, it's under a different chapter, 31B 12. And so if we're talking about the photo, we can address that amendment. If we're also talking about whether or not we want a solo or two witnesses, they're two separate amendments because they're in two places of the chapter.
So I guess my concern, and it's hard to legislate from from the dais, right? My concern is going to be if it's a one-party complaint, then how do you verify that complaint? And and in terms of the noise, I have a neighbor who's used an electric leaf blower for years, and it's noisy, right? And so I think in this regard, we're going to have complaints about leaf blowers because I think there's an expectation that they're silent. And so I have a concern that we're going to get a lot of complaints that just because somebody's using a leaf blower, not necessarily a gas leaf blower. So I don't know how what are your thoughts in terms of how you're going to be able to enforce this?
Yeah, so for years, the county has had the limit on leaf blowing equipment, a 70 decibel limit, which is different than our noise limits for other things. The county, our county staff can go out to a property, or if they get a complaint, they can call a landscape company, for example, and say, we're going to come out and test your equipment. There's a procedure you go through to test the equipment and see if it exceeds the 70 decibel limit. The ban on gas-powered leaf blowers is, unlike any other provision in noise law, it's not based on sound, it's based on, it's a gas-powered piece of equipment. So, but you may be right. People may, and still can, call us and say, or contact us and say, we have a neighbor that uses an electric leaf blower. We think it violates the other provision of the county's noise law, which is that 70 decibel limit. And then we would have to arrange to go out and test. That is difficult. It's time consuming. There's a whole process because you have to be certain distance away from the noise meter and take it from different sides. And so that's always been difficult. Generally, pieces of equipment have a decibel level on the piece of equipment, but sometimes that label's gone or the equipment's not functioning properly. So that is a challenge. I don't know that changing the complaint form without photographic evidence is going to change that. We could still get those complaints. You asked about how would we prove the complaint. Well, the basis of whether it's a two-party or one-party complaint is the person who's doing the complaining has to be willing to come to court if it gets to that stage, because they are the witness. The county is not the witness. So they would go to court and say, yes, we witnessed the use of the gas-powered leaf blower. And the landscape company would offer their side of the story, and then the judge would adjudicate that.
Thank you, Mr. Edwards, for that. I really want to push DEP to figure out a remedy that works best, because it's important to remind everyone the original legislation was proposed by the county executive. And this component of it was proposed by the county executive. And so as we're trying to figure out how it is enforced, it is ultimately DEP currently that would enforce it. During the course of this conversation, I've been looking at various other jurisdictions, and the District of Columbia actually has a complaint form that goes to an agency that we don't have here, right? Basically a compliance agency that deals with community complaints. And that complaint submitted online to consumer complaint form has 4 criteria: the name of the company or individual alleged to have used a gas-powered leaf blower, the location of the alleged violation, the date and time, and any additional identifying information. And then it says photographic or recorded video in support may be submitted but is not required. And then at the same time, I'm just looking at other jurisdictions around the country that already have this enforced as law, as we do now in Montgomery County. The state of California Portland, Oregon, Burlington, Vermont, Evanston, Illinois. Some could argue they have more deciduous trees than we have here, right? And so this is an issue longer than just 3 months, perhaps. But has the department taken any look into see how other jurisdictions do this?
So we have an online complaint form that you can access it through our website. If you go to 311 and put in the keyword leaf blower, or call 311 and say, I have a leaf blower complaint, they'll send you to that online form. And so it asks for the information you just discussed.
Right, but the key difference here is ours requires photographic evidence.
Right.
Right.
Only because the law required photographic evidence. We can remove that provision and remove that from the leaf blower complaint form and just ask for the name of the complainant, the alleged violator, address, company name, information about
More
the
akin
company.
to what the district has.
I sounds like it would be.
Yeah, right.
similar.
It sounds like that's
Yep.
correct. So, Ms. McCartney-Green, while that requirement is in the law, does it need a legislative change, or can it be? Can there be an amendment made to the regulation?
Yeah, and I'm just going to read into the record what the law actually says. Looking at Section 31B9, Section J, that says an enforcement officer may issue a civil citation under this section if the director receives a complaint of noise disturbance supported by photographic evidence of violation of the use of the leaf blower. So they may use it, and it gives a broad authority. If the committee is saying that we don't want that to be considered at all, we would have to amend that section to essentially bracket out the entire section, to be honest, because they wouldn't be using the photographic evidence. Now, that doesn't take away from the two-complaint system that the DEP still would be able to use in the form that they have. I guess from a logistical standpoint, you wouldn't have a place to upload a photo, from my understanding.
Can you read one more time? I'm looking
Sure.
at it, but it's the may.
Correct.
Right?
An enforcement officer may issue a civil citation. A civil citation, it's a Class A violation, it's 500. If the director receives a complaint of a noise disturbance supported by photographic evidence of violation of the use.
Conditional on the photographic evidence.
Correct.
Councilmember Luthi.
All right. I beg to differ that the may modifies the photograph. The may, as you read it, modifies whether or not the citation is issued. And the conditions met in order to even consider the permissive use, may issue citation, is that there's a complaint and photographic evidence. Is that right?
Yes, so if I said it incorrectly, I want to reiterate that the interpretation by Councilmember Lukey, the may is predicated on if the enforcement officer issues a citation. Make sure
It's predicated on the citation not even being considered to be able to be issued unless there is in fact a complaint and it is accompanied by photographic evidence in the way you read it, because it's what the enforcement officer can do. It's not about whether the complainant may or might submit the photo. The may is about what the enforcement officer does, and it's permissive as to whether they bother to issue the citation. It's not mandatory.
it's not mandatory. The recommendation here would be to remove it for clarity.
Mm-hmm. And remove the photographic evidence.
Yes.
Right. But then it is still permissive as to whether or not the citation gets issued,
Yes.
correct?
Yes.
Okay. And then just because I might have had some things recently that deal with noise enforcement, might have, that's a Monday through Friday 9 to 5 thing, right? No offense, but when are people most likely to get their knickers in a twist over noise? On the weekends or in the evenings. But like typically a lot of yard work happens on the weekends when people are not at work, especially for residential. I'm going to confine this to like individuals' residential use, right? So, or after work, right? When the long hours are we still have daylight, right? You can do that. And so that raises the issue of how long is it going to take to go back out and check the equipment? And then Is it clear? Because we've had other issues where, you know, different agencies have decided, county agencies, I should say, have decided the juice isn't worth the squeeze on going to court on this thing because people aren't going to show up, the complainant's not going to show up, or the fine is too little, it's permissive. So there's a lot here that says to me, how strong is this enforcement mechanism? How does it work? Is it gonna work? And I know it'll take time to bear that out, but I have I'm not a gambler, but I have a sneaking suspicion. What we're gonna find out is a lot of people fill out the complaint form, and a lot of people don't wanna go to the district court to deal with this, right? And district court dockets get filled with stuff. It may be a long time away. It might be 9 months away, and then it pops up as you know, you get your scheduled court time, and it's 9 months after you got really mad about a leaf blower at your neighbor's house, right? And so the feeling 9 months later is vastly different. And I just want to put that out there because it's the practical things about how this all works that I think are really important, and it's a question of how significant is that going to be in terms of getting us, again, to the goal or to the desired objective that you want, which is more environmentally friendly landscaping tools, right? But I do have significant questions about the enforcement mechanism, regardless of whether you take the photographic evidence out or not. And yes, I'd like it to go because I just don't think it's great having photographic evidence of your neighbors when you're having a problem. We can be more mature about how we settle these questions. Thank you.
Thank you. So the issue before us requires a legislative fix. That much we've figured out. And I think we all agree that it does need to be fixed. The question is, how do we do that? The question is whether or not this legislation gets amended to include that fix, with the additional question that Mr. Edwards raised about single source or two sourcing for filing the complaint. I do think that there should be more time, more research as to how the other jurisdictions, in addition to just the District of Columbia that I've already stated out there, and put into the record how they do it. But I think there is agreement that we need to remedy this. The question is just, how do we do that? Councilmember Stewart noted in the beginning that she's been working on this issue when she was the mayor of Tacoma Park. I have long said that I support the underlying bill, which is why it finally moved forward through the committee and through the council. And while I do note that it is a noise ordinance bill at its heart, there are a lot of other things that this legislation does, that the prohibition of gas-powered leaf blowers, it really is requiring us to think differently about lawn care, about how we as a community are good stewards to our environment. It is for the same reasons that just last month I introduced legislation regarding invasive plants and wanting there to be more native species and more pollinators. And we know that those pollinators come about because there are leaves on the ground for them to burrow and to lay their eggs and to cover during the winter, be it caterpillars, moths, butterflies, ground burrowing bees, the soil health. There are a lot of secondary and tertiary benefits from rethinking the way that we manage our lawns, because it's only been about 50 or 60 years that we've been operating this way. And so this is a bigger conversation. But most directly and acutely right now, it is about noise. And so for those reasons, I don't support the legislation either, but want to figure out how we can modify the current law to do right by those who are doing the work, right? Especially in this time of great fear in our community and in our country, especially for those who do this work and are our neighbors. I don't know if Councilmember Alvarez, I saw you. Yes, you want to make some comments?
Thank you, Mr. Chair. Just a couple of questions. Mr. Edwards, thank you so much. Again, appreciate those comments. In DEP's report, could you elaborate on the paragraph that talked about the transition and timing of the county ban? You've had the opportunity to speak, DEP, with a number of landscaping companies. What have they been reporting back to you? They shared their testimony with us. Is what they shared in their testimony consistent with what they have shared with you? And are you all at all concerned about this transition happening this fall?
I guess I would ask my colleagues who have probably had more conversations with the landscapers than I have, what the feedback is they've gotten.
I will have to say that they don't approach us a lot. We approach them. Most of the conversations that have been in the field. I've done a fair bit of driving around, finding landscapers at work and also at the transfer station at the yard trim area, speaking with them, albeit often briefly, about the rebate program and what's available to them out there. Every landscaper is different in their vociferousness about the law or their compliance with the law. You have some landscapers who grin and bear it and say, we're doing fine. It's hard, but we're doing fine. And you have others who get on your back about how this is going to put them out of business and they're not going to be able to operate in the county, et cetera. And it can be very just dependent on the individual landscaper. They're a very adaptable crowd, so they know that they can make the change, and they have been making the change. They will say it's difficult. I do ask them questions about, what brand are you using? For example, what have you transitioned to? There's a lot of differences between the makes and models of these, the equipment. There's different balance loads if you see a landscaper with one just thrown over their shoulder, when it's a gas blower, the weight of it is very different than if they just do that with an electric blower. So there are modifications out there, and we do know there's landscapers out there who successfully have been operating with them. They all have different opinions. I would say it leans more towards complaining about the law because change is difficult. Anything you change for somebody, you're going to find that they're going to say it's challenging. I speak often with our retailers who are part of the rebate program, and as you mentioned, Councilmember Balcom, going to Home Depot, they, even before the law went into place, they weren't selling gas equipment. They had mostly eliminated gas blowers off of their shelves, so it's what people are buying, it's what people are using, and they are working a lot with the landscapers on educating them about what the best equipment is, what's the most efficient use of the equipment, how to adapt to the equipment, how to deal with the challenges, and they're a really good source as well within our community. The retailers that are out there, and they are not, now of course they make money on equipment, selling equipment obviously, but none of them have expressed that there has been a lot of challenges with the sales end of things, that people are coming in and they're trying to learn and they're trying to make a difference in what they're doing.
Thank you, I appreciate that. So that of course is covering now when leaf blowers aren't needed as often as during because the need for them increases significantly between now and the actual leaf falling months. Again, do you think they're prepared? Do you feel confident that the industry is going to be ready to be able to comply with the law, in your professional opinion, starting in October?
I feel that they're all on the same footing in being prepared to be compliant with the law. Some are more advanced in having started to make the change in the past. Those that have made the investment in previous years are that much farther on the return on investment on the equipment. And there's an average of 1 to 2 years for the return on investment in equipment. And then there's very low cost to operate the machines. So some of them are a little farther ahead, but they are on equal footing. They will find equal challenges with making the change. to each other. And so therefore, I feel that equity across the board, that they're all on the same footing, does make a big difference in how they're operating. They're learning from each other. We had a wonderful workshop this year where we educated a lot of landscapers. We had professionals in giving them advice and tips on how to make the transition. We continue to work towards efforts and spend our funding towards doing that level of education. I feel that that is very supportive of the industry as well.
Yeah, and without a doubt, everybody that testified is embracing electric. They know that's where it's coming. I think it's just this transition period where people express concern. With regards to the reporting, how many people do you all have on staff that are responsible for oversight when a complaint is driven? How many people are responsible for following up on that complaint?
We have 6 environmental investigators that cover all our environmental code.
Got it. And they work traditional hours, I assume.
Monday through Friday, 8 to 7 to 5, different schedules, but yeah.
Got it.
Traditional work day, yeah.
And what often happens when a county resident gets frustrated, they'll call 311, sometimes they call law enforcement. What has been your experience? You're about to significantly ratchet up the requirements. So how are you all going to address and handle that? How is the executive branch educating 311 and other branches of government regarding the execution of this bill?
All right. So we have, as we talked about when the original bill was discussed, we have a 4-stage enforcement process. The first is to contact the alleged violator with an information letter. The second is a warning letter. Neither one of those is an official enforcement action. The third step is a notice of violation, which is an enforcement action but without a civil citation. And the fourth is a civil citation. Because we believe education is important, even though there's been a lot of talk about this, we can never be sure that everybody is up to speed on what's going on. So we will continue to do that. The reason the 2-party noise complaint, again, was put in for other noise issues and for this law was that we don't work around the clock. We are Monday through Friday. So allowing someone to file the complaint at their own time in the evening and the weekends, that will still come to us. We'll have the information we need to move forward with an enforcement action. And then it will be up to the alleged violator how they want to handle that. They could either pay the fine if we've gotten to that stage, or they could read the information letter and then the warning letter and say, okay, we need to change our practices. And then if they get a citation, they can challenge that in court, just like any other citation. And then again, we don't have experience with the court, how they'll deal with it.
Thank you. And can you remind everybody, what is the fine?
The fine is Class A violation, so $500 for a first offense, $750 for a subsequent offense.
Say that.
$750 for a subsequent offense.
Got it, for each offense.
Yeah.
Okay. We have a bill before us. This could be a vehicle to introduce a component of the bill that it seems like there's universal agreement on. Very much respect, obviously, the will of the committee. Timing is of the essence here if we're going to enact something, because I'm not concerned about the next several months. It's October, November, December, when many more of these pieces of equipment will be out in the field. And just, news and notes, WSSC is doing work on my neighborhood right now. The contractors that they're using are using gas-powered leaf blowers. And that is a government construct and agency by extension. And they didn't have the message. So it's going to take a while to implement, but once we actually see when most of these are going to be in use, that's when I'm have the deepest concern. So I don't know, Ms. McCartney-Green, if, and I'd be open to if there's a motion for just adding that particular amendment. I'm not confident that the rest of the bill will pass as it moves through and we go before full council, but it could be a vehicle to get us further along than we are now and more rapidly, because my concern is that if we have to draw a new piece of legislation, having it go through the process, we know how passionate people are about leaf blowers. Is there enough time for us to be able to move this forward with fidelity by October when we're going to see more of these incidences? So those are just my comments.
Appreciate all of that and the thoughtful approach there. We do need to remedy the enforcement mechanism because we know that a large number of individuals who are doing this work are Latino and immigrant men. And in this era of Donald Trump, we should not be encouraging our neighbors to be taking photos of our neighbors. Full stop. And the question, as Councilmember Albornoz just noted, is how do we amend that section of the law? Given that this particular piece of legislation has garnered a lot of interest across the board, I don't think that amending this legislation is the right way to do that. I've heard there are two of the three of us who don't support the legislation, and I think it could be very easily misconstrued in the public if even a severely amended form of this legislation were to move forward. And what I would be supportive of and open to comments from everybody here is letting the committee make a decision on this and then move forward with a piece of legislation, all five of us, the committee, whomever else wants, to introduce legislation amending the enforcement mechanism, which thereby allows us to have a deeper conversation, whether it's single source or double source, for that monitoring aspect as well. I open that up for conversation among colleagues. Councilmember Stewart.
Yeah, I appreciate that. I do think it gets, as the conversation today got confusing, and I think I would be concerned here to try and amend this without fully thinking through, and we have understanding the urgency of this. But I think it's the more prudent way to kind of take a step back, look at the enforcement. Are there other things here that we haven't been raised yet? As you know, DEP is experiencing this. One thing was raised about the one-party or two-party verification. But I think it's best to this is the bill that was introduced. This is what the public thought we were discussing today, and then to come back on the enforcement piece. So,
Councilmember Malcolm.
Yeah, I think that there's two ways to do it, and I do think that it while I'm a co-sponsor of this bill, of course I would like to see it move forward. I think it does muddy the waters in terms of what this legislation is going to do. Do we have a, from the perspective of the May, language of May, not the month, do we have the opportunity now to direct, or does the county executive have the, of course the county executive does, direct that can we not use photos in enforcement without the legislation and then clean it up later, or do we need to have that legislative fix before somebody instructs or they decide on their own to not do that?
When it comes to legislation, you try to avoid ambiguity. And I'm concerned whether different interpretation, especially we haven't had like a full case being brought to trial whether the photographic evidence was needed or not, or whether the two parts. So my recommendation is that if the committee wants to clear that up, then that's important to address that, than to, I don't want to say haphazardly, but basically say, not to enforce as much. Does the CE and DEP have discretion here? Yes, that's clear. But as mentioned, part of the complaint is that they receive a photographic evidence, and that's important that that's there. And if someone uses that process, that's what the law has provided here.
Mm-hmm. And all the 76 cases that you've received, they all have photos?
Yes.
So they cannot submit a complaint without photographic evidence? Correct.
Because that's what the law now
Sure.
requires. I'll just say that I don't think the may is the issue, because under Section 31B-12, which is the enforcement section, it says an enforcement officer may issue a civil citation for any violation of this chapter. So we always have discretion about whether to issue an enforcement action. That's not unique to the leaf blower law. But the requirement to have photographic evidence is, at least according to my understanding, is a requirement
Right.
to move forward with a citation for the leaf blower law. You don't have to move forward, but if you're going to move forward, you have to have a photograph under the current law.
Yeah, I just think that I mean, if we're thinking time-wise, I mean, even if we use this vehicle, the 1925, it's still not going to be in place until mid to end of September. I am concerned that we're three people a day are taking pictures of men typically using these leaf blowers in our community. I mean, that's disturbing. So, I mean, I don't have a solution here. Just voicing the problem.
So, right. It is a situation that we're in where it sounds like the will of the committee is to not provide this exemption, but that there is, I would venture to say, nearly universal support for amending the violation process. And the question is, how do we do that? Just want to close by trying to square this circle that I keep hearing. Mr. Edwards, you were reading various aspects of the law and saying that the photo requirement is not necessary. Can you repeat that last thought you just shared?
Yeah, so the enforcement section of the law says an enforcement action may be taken for any violation of Chapter 31B. And that's true of all our environmental codes. You may issue an enforcement action. You don't have to, but you may. But if we are going to move forward with a violation of the gas-powered leaf blower law, the way the law is currently written, we do have to have photographic evidence to move forward. We don't have to move forward with a complaint, but if we're going to, we have to have the photographic evidence. So,
what other remedies could the department conceive to try and whether enforce or educate, right?
So I'm not an attorney, and I won't make a bad joke about that, but we could, I assume, and I want to consult with the county attorneys on this, but we could not move forward with any enforcement of gas-powered leaf blower complaints, because you may issue an enforcement action. So we could say we're not issuing any complaints. We could go to the process of issuing information letters, warning letters, but not go forward with an enforcement action. Now, and we could take the requirement off the form to issue a photograph. We could make it difficult for someone to attach a photograph, even though the law says you have to have a photograph. Now, I don't think that's going to be well received by people who want to complain about the use of a gas or powered leaf blower, but I would assume there's some discretion that we could be directed. Say we don't want to issue any citations because we don't want to get pictures of this. But again, that would have to be discussed by the county attorney and the county executive, I assume.
No, it's we were going down the same path, I think, in terms of wanting to find a resolution to this and understanding that. And again, I think going back to and remembering the conversation that we all had around the original bill, our emphasis was on education, outreach, helping people transition, particularly in the first full year that this went into effect. So I think saying that we're not moving towards violations actually is in line with the intent of this council when we passed the original bill. And so I would be comfortable if we could talk in the interim with the county attorney, with Ms. McCartney Green, to figure out how we can do that, and then come back in September with an expedited bill to change the enforcement part of this this legislation. Yeah. Oh, sorry, I'm not sure.
Yeah, no.
She's really good at that.
Agree, and Councilmember Lutke.
Just want to be clear, and thank you for reiterating sort of the tone of what we were all saying as we did the original bill, and that's important because again, if anybody tries to go to court under the current framework, but does not attach a photo, you do not have a case, right? And we can't, by legislative intent, leave a word in the statute and then tell the judge, pretend it's not there. That doesn't work that way, right? So basically, if that's the tact that everyone is going to take, then no enforcement actions at the court level should be taken during that time period, and then additional time frame to resolve how you want to phrase it and how you want the enforcement mechanism to work and refine that can take place over this next year. But that's kind of the box that we're put in, right? So that's all.
Thank you. Councilmember Alvarez.
Thank you. Quite a conundrum. So a couple thoughts. One, people are still going to take pictures. We can't stop them from doing that. We can let them know that we aren't actually going to enforce it for some designated period of time until we have the legislation. But you all are receiving 3 complaints per day right now, starting in October. Once many more of these pieces of equipment are going to be out there, you're going to be receiving many more than 3 per day. So I think the education will have to be on both sides, both for the landscaping industry and our community, because I think the county executive, shooting from the hip, probably said that, well, we should encourage pictures but not take pictures of people's faces, which is totally unpractical. So I think I think it's the least worst option probably in the short term, but I do think we'll have to dissuade residents from taking those pictures while we figure this out.
Thank you. And as I heard Mr. Edwards, or think I heard Mr. Edwards, you can amend the online complaint form, right?
Yes, right now, in order to submit the complaint, you have to fill out required fields. One of the required fields is a photograph, so we could delete that provision.
We can amend that nearly immediately once we fix the IT.
Yeah, yes, we can do that.
And so, thank you. Unless anyone has any other comments, I think this conversation has shown us a few different things. First, that we want to do right by those who are doing this work, and we are going to work through that legislative remedy. If we were to amend the bill that is before us, I think it creates greater confusion among the community, and this is, I think, the best way to move forward. At the same time, it really, I don't think it changes things on the ground. I think everybody knows what the law is. And I even know that while my husband and I do all our lawn care work with all electric equipment, our neighbor has somebody who does it for him. And 2 weeks ago when he came by, he and his one employee, they had already converted to electric. And the spirit of the conversation that we've had, everybody knows what the law is. And so that conversion has happened. It's continuing to happen. And when, should a neighbor see somebody who is doing work with a gas-powered leaf blower, as experience has shown us already in the last 3 weeks, 4 weeks, they're not going to be shy in telling them what the law is. What we are changing is how they file that formal complaint. And the conversation I hope that comes out of this committee work session, out of the committee, out of this council, is please do not take photographs of individuals outside doing yard work. Regardless of the equipment that they are using, it is not a safe environment, politically speaking, to take pictures of our neighbors at the same time when we know federal law enforcement officials are also coming into our neighborhoods and taking people away. Don't do it. Contact us as you have been. Tell us that there are contractors who are not yet complying. We can have conversations. The Department of Environmental Protection, in the interim, can reach out to those lawn care companies. Can we get that agreement from you all now? That if we share with you that there might be violations, that you can reach out and inform folks of what the law is?
Sure. I think this is it's an awkward spot we're in now because we have a law that says you must provide you can't use a leaf blower, you must provide photographic evidence, and yet we're making it difficult to do that and not encouraging people to do that, which I fully understand, but it puts DEP kind of in a squeeze between those folks that want to file a complaint and those folks who don't want to be complained on, which I understand both sides, but so we will navigate this as best we can.
What about, and here's a different take, the photographic evidence? Can it be of the vehicles, non-personal?
So we've, in our form, we say any information you can provide, like a truck license plate number or the side of a truck that has the name of the company, because we're not interested in the individual. We're interested in the company because we want to, it would be the company that would be, or the homeowner who would be subject to the enforcement action. So most of the pictures we have gotten have been of vehicles of a person from the back with a gas-powered leaf blower because you want to see the evidence that it's a gas-powered leaf blower. Mm-hmm. We don't have a lot of pictures that have clear faces, but again, I understand the concern. So
we want to dissuade that.
Yeah.
Right.
I just think, I mean, I appreciate the line, and I'm hoping this will not take us very long to do an expedited bill in the fall. I just think, I appreciate where we were 2 years ago when we wrote this, even though some of us already had conversations about how we were uncomfortable with the photographs. But I think we are just in such a different time right now. And the idea of any neighbor taking a picture of someone else or some stranger taking a picture of someone, it sends a very different message right now. And we didn't anticipate that 2 years ago. I think we're in a very different climate. And I think if we're doing education and outreach, but we're delaying the actual enforcement by 2-3 months, we are still keeping this bill intact moving forward and the ban intact, and we will do this work. But if that means we are not making anyone feel uncomfortable, if that means we're not discouraging people to go to work out of fear, then we should continue to do this, and the enforcement will come.
Thank you, and I'll just add that I think the benefits of the law are already taking effect. The transitions are happening. Lawn care companies are stopping by and large, and whether or not there's a delay in the enforcement, positive change has already occurred and will continue occurring. So without any other comments on this piece of legislation, we'll take a formal vote by the committee. All those in favor of expedited bill 1925, raise your hand. All those against? Okay, that is 2-1 against the legislation. Councilmember Albornoz, thank you again for your concern for all the different factors and parties here. We are going to continue this conversation. Hopefully we can all do this together in coordination with the executive and DEP. That is it for our agenda today. We are adjourned.